I think the moot court is a fantastic way to engage the law in a more practical sense. You're received a problem which is a real life problem, and you can engage the law where you learn the research skills and you get to research on your own and develop arguments which you think can be put forward in front of a judge.
You look at the content of what they're presenting to you, the way they present it in the fact of logical presentation, but then the physical presentation is very important. If someone is pleasing in their manner, then they are going to do better, because after all, advocacy is the art of persuasion.
Today we're presently arguing a torts case regarding causation primarily, about an individual who was intoxicated upon a property and whether or not it's justified for liability to be conferred upon our client.
In the matter of Bartell and Black, good morning ladies and gentlemen, could I have the appearances please?
I think that Western Sydney has a really practically grounded degree. So I speak to a lot of law students from other universities that don't get to ever do a moot or a negotiation or any of those practical assessments. Whereas at Western Sydney, you actually get to do a number of them, even in first year all the way through to fifth year.
Your Honour, as a respondent, we submit that Chamberlain District Court Judge was correct in finding in law that the defendant's duty of care extended to the jetty from which the plaintiff jumped.
Can I take you to paragraph 23 of the first instance judgment?
You have to be confident in the way you speak, have to articulate yourself clearly, and know your problem inside out.
The person driving the car in this case. I think oral submissions are so important because it's your opportunity to explain to not only the other side, but also to the judge in particular, what your argument is and really flesh out what you've been able to write down. Because there are a lot of restrictions on written submissions and how much you can submit and what you can say, whereas oral submissions are your opportunity to really give those written submissions charisma and really explain to the judge exactly how this is working from your side. I will be dealing with submission 2 and 3, that the appellant in this case breached his duty of care to the respondent.
Your Honour, it is our primary submission at section 50 of the Civil Liability Act, I believe it's subsection 3, which states that the presence of an intoxicated individual does not alter the duty which is owed by the landowner in the present circumstances.
If people want to go into practice as advocates, either at the bar or solicitors, having some idea of what's confronting them, rather than like my generation being handed a file, told to go and sort it out, is A, better for the student, or the young graduate obviously, but better for the clients, for the public that they represent. Ms Nicholson, I've got a difficulty. Why, as a matter of forensic judgment, even common sense, should counsel not have been joined in these proceedings? Can you assist me in that respect? In real life, you are often asking questions because you genuinely need to know something that hasn't quite been said, you need something expanded on, or you need to remind people from time to time of something that they may have forgotten.
I refer to the case of Ball and Mikowski and another, a 2000 decision of the Queensland Court of Appeal at Index 521.
There's nothing worse than a judge or tribunal that just sits there and gives you nothing. Of course, there's a slight twist in that, isn't there? The actual injury did not occur directly from the land owned by your client.
Western Sydney University has a very strong focus on how the application of the law operates in the real world. This means that when you do go into the real world and start working on the law, which is the objective of many of our graduates, that you're not shocked by the culture which you're going into.
The harm which presented was not remote. I think this is the pinnacle of your law degree, seeing how you can actually put everything together in one way and do so in 10 minutes in a really succinct time frame is a fantastic way to challenge yourself and put forward the law that you've learned throughout your degree.
And would have likely prevented the harm from occurring because of that alertion to the risk. Western Sydney has some amazing opportunities that you can't necessarily get at other universities. And I think I would just strongly encourage students to take advantage of every opportunity that they can, to whether it be to do mooting, other competitions, alumni events, meet their lecturers, meet practitioners, whatever it is, take advantage of those opportunities because you don't realise how important they are.
What we have are people here who want to make their way in the world. That gives every indication that they'll make successful practitioners who are out there helping people who need help. Because after all, people only come to lawyers when they're in trouble.